case briefs, and so much more. LSData's got what you're looking for.
In 1973, the Supreme Court of the United States heard the case of Georgia v. United States, which revolved around the requirement for states to obtain permission from the Attorney General or federal district court before changing their election laws or constitutions. This requirement, known as Section 5 of the Voting Rights Act, aimed to ensure that changes would not prevent people from voting based on their race or color. The case began when the state of Georgia was sued by the U.S. Attorney General for conducting elections without obtaining clearance under the Voting Rights Act of 1965. Georgia subsequently submitted its reapportionment plans for 1971 and 1972 to the Attorney General, who objected to the plans due to their use of multi-member districts and majority runoff elections, which deviated from the state's prior policy. Georgia failed to enact a new plan, leading the Attorney General to bring a lawsuit. The district court initially ruled to uphold the changes made in the disputed 1972 plan and issued an injunction, which Georgia appealed. The Supreme Court, however, sided with the lower court, affirming the plan's constitutionality under Section 5 of the Voting Rights Act. The court decided that new elections were not required at the time since the disputed 1972 elections had already occurred. The Supreme Court ultimately directed Georgia to halt any future House reapportionment plan elections unless an approved plan was submitted, sending the case back to the district court for further action.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.